Next one is about the judiciary. Provision related about the judiciary. Next topic is about the judiciary. So in that, uh, transfer of judges. Okay. So topic number 1 is addition and transfer of the judges. First one is the addition and transfer and addition and transfer of the judges. Okay, so this parliament recently passed the legislation to increase the strength of the Supreme Court. Before that it was 31 strength, now presently it is 34. Okay, 34 including the Chief Justice of India. Okay, so originally under article 124, there was the Indian Constitution, the strength of the Supreme Court was fixed, and that was 8, 1 Chief Justice and 7 other judges. So the strength was fixed, and that was the strength was fixed, and that was 1 Chief Justice, and additionally there was 8 more judges. 8 more judges was there. Okay, so this was under article 124. Presently the strength is 34. 34 judges are there. So the parliament through the Supreme Court Act was increased the strength, and last amended in the 2009, and it was to 25 to 31. Okay, so that was the addition of the judges. Now next one is a transfer of judges. Next one is a transfer of judges. So about the transfer of judges, there is a Chief Justice of Madras High Court transferred the Meghalaya High Court. So Madras High Court judge was transferred in the Meghalaya High Court, and that was constitutional provision of article 222. Article 222(1) that decide about the constitution with the Chief Justice of India, and the article 222(1) that was the transfer of the judges and High Court to another High Court. So judicial interpretation, the Supreme Court derive its power to select, appoint and transfer of the judges. Transfer of judge cannot be punitive measure. Transfer can be ordered only on the public interest. So one thing is, transfer will be only for the public interest. It will only be the public interest. Okay, and transfer can be ordered only the public interest and better administration of the justice. For the better administration of the justice. Okay, and transfer can be ordered by the president. It will ordered by the president only on the basis of the CJI after effective consultation. So first consultation with the CJI. First there must be a consultation with the CJI, and after then the transfer order will be after then there will be the transfer order. So first will be the consultation with the CJI, after then only. Okay, first just case, that was the SP Gupta case. SP and Gupta case. This SP Gupta case was the Supreme Court rule that the recommendation made by the CJI can be refused from cogent reason. So there must be a cogent reason. After then refusal will be there. Second judge case was in 19 and 93. So see, 3 judge case was there. One first judge case that was in 1981. Second judge case that was in 1990 and 3, and that judge case was Advocate the Record Association, Advocate of the Record, and that was CJI only need to consult the 2 senior most judges, and collegium may or may not change their recommendation, but these recommendation are binding. Okay, so advocate on the court of record, that was under the second judge case. Now third judge case was in 1998. In 1998 there was a third judge case, and that was CJI should consult with 4 senior most judge. In the second judge case there was a 2 senior most judge, but in the third judge case there is a 4 senior most judge. 4 senior most judges are there. Okay, and that transfer to form his opinion on judicial appointments and transfer will be according to that. So this 3 judges case was there for the transfer of judges. Now next topics regarding the judiciary is acting chief justice. What is about the acting chief justice? Acting chief justice. So Supreme Court has recently ruled judge who retired from acting chief justice High Court cannot be claimed the pension. So if he retired from the High Court, then he will never claim about the pension. So pension will never be claimed from this person. So under article 233 state the president can appoint a judge of the High Court. Okay, so president will appoint the judge of the High Court. That was under 223. Okay, and the office of the Chief Justice of the High Court, if it is vacant, and Chief Justice of High Court is temporary अगर वो absent हो. Okay, temporary अगर वो absent हो, temporarily absent. And third one is unable to perform his duty. If his office was vacant, if he was temporarily absent or unable to perform his duty, then similarly under Article 126, President can appoint a judge of Supreme Court. So President can appoint a judge of Supreme Court, and that as an acting chief justice. As an acting chief justice, President will appoint this person. Okay, so the office of Chief Justice of India is vacant हो, या फिर Chief Justice of India temporary absent हो, otherwise Chief Justice of India unable to perform his duty. In that case only President can appoint judge for the High Court under Article 223 and under Article 126 for the Supreme Court. So under 223 and the 126, that is the acting Chief Justice of High Court. Okay, now regional bench of the Supreme Court. What about the regional bench of the Supreme Court? So Vice President of India suggested setting up a regional benches for the Supreme Court in the Delhi. Okay, so what is about the regional benches? That is comes under the Article 130. That Supreme Court may place Delhi order for Chief Justice of India with the prior approval of the President. So that was National Court of Appeal with regional benches at Chennai, Mumbai and the Kolkata, and National Court of Appeal with the regional benches with Chennai, Mumbai, Kolkata is meant to act as a final court of justice in dealing with the decision of High Court. So this will deal with the decision of the High Court and like civil, criminal and labor related issues. So this is about the regional benches. Now next topic is about the Gram Nyayalaya. Okay, so this Gram Nyayalaya is the Supreme Court plus the all state. So this is the Gram Nyayalaya within a month and ask the High Court to expedite the process of consultation. So 144, that is 114 report. Okay, this is the Law Commission report. This is the Law Commission report of 1986, and that was Mobile Village Court is also there. Mobile Village Court assist to justice for the 4 marginalized people. Justice for marginalized people. Okay, justice for marginalized people. Reduce the delay. So one is reduce the delay reduce the workload, वर्कलोड को रिड्यूस करना है. ग्राम न्यायालय एक्ट वॉज देयर. सो ग्राम न्यायालय act that was in 2008. Okay, this act was came into force in 2009, and this is set up under the act. Central government allocated about the 1400 crore rupees, 1400 crore rupees by way of assistance, and presently 11 state has taken the step notify as a gram nyayalay. 11 state for notifying the gram nyayalay. ग्राम न्यायालय के लिए 11 स्टेट थे. नाउ स्ट्रक्चर ऑफ ग्राम न्यायालय, दैट इज इट इज एस्टेब्लिश्ड इंटरमीडिएट लेवल ग्रुप ऑफ कॉन्टिजियस पंचायत. नाउ स्टेट गवर्नमेंट दैट इज नोटिफाइंग द बाउंड्रीज, इट विल नोटिफाई द बाउंड्रीज ऑफ ग्राम न्यायालय, ऑफ द ग्राम न्यायालय. इट विल नोटिफाई द बाउंड्री ऑफ द ग्राम न्यायालय. अपॉइंटमेंट ऑफ द state government, that is presiding officer, it will be the nyayadikari will be the appointment. And matters related to the judicial magistrate of the first class. So who will see the gram nyayalaya matter? That will be the judicial magistrate of first class, judicial magistrate of the first class, okay. So the salary and the other allowances along with the other terms of condition service and shall be given to the SC, ST and women. Jurisdiction power authority, gram nyayalaya shall exercise both civil and criminal power. So one thing is about the gram nyayalaya, that is it will deal with the civil power as well as the criminal power. Both types of the power is given here. Okay, and next one is gram nyayalaya shall have a deemed to be decree. Okay, and gram nyayalaya can be try the criminal cases, civil cases and disputes or another dispute. So it will deal with that. Offense not punishable with death, imprisonment for life, or imprisonment for a term of exceeding of 2 years. That's do not comes under this gram nyayalaya. Okay, an offense related to the Central Act. So one was offense related to the death and more than 2 years. The imprisonment of the more than 2 years, that will not comes in that. And second is offense related to the Central Act. Offense related to the Central Act, that will also not come in that. Okay, like payment wages, minimum wages, protection of the civil right. Nature jurisdiction of the specified amend by both center and the state. So it will amend by both. First is the center, second will be the state. Okay, second will be the state. Not bound by the rules. Gram nyayalaya is not bound by the rules, but Indian Evidence Act, but it guided by the principle of natural justice. It is guided by the principle of natural justice. Okay, principle of the natural justice. And gram nyayalaya is not bound by the rules, but Indian Evidence Act, but it guided by the principle of natural justice. So Indian Evidence Act is not there. Indian Evidence Act is not there. Okay, that Indian Evidence Act is not there, but it is guided by the principle of natural justice. Appeal against the judgment of the criminal court shall be taken by the court of session, by the civil court, by the district court. So civil matter will be decided by the district court, and the other matter will be like criminal matter. So criminal matter will be decided by the session court. Okay, so this all about gram nyayalaya. And the Indian Evidence Act is guided by the principle of natural justice. So gram nyayalaya is not bound by the rules of evidences provided in Indian Evidence Act. Okay, so this is not bound by the Indian Evidence Act, guided by the principle of natural justice. So this is about the gram